Hey everyone, Harry here to talk about Scott Perry's cell phone. So, you may remember back in August, I want to say the FBI seized Perry's cell phone with good reason and with judicial authorization. There are you may remember, five members of Congress who the January 6th committee tried to subpoena, and everyone thumbed their nose at the committee, including, by the way, Jim Jordan, who's now gone subpoena happy and is issuing them in his new role as chair of the Judiciary Committee. But Perry, in some ways, was the strongest candidate to get a subpoena because all five of them had some involvement on the actual fifth and sixth. Perry really was a co-conspirator for one of the big themes. That theme being the whole attempted coup, I think is the right word, of the Department of Justice. So remember what happened there. A mid-level bureaucrat, basically, a guy who's an acting assistant attorney general, gets his head turned with a series of conversations with Trump himself, who is planning to make him the attorney general. And there's some indication that there was even a time where Trump thought it had happened. He's listed as attorney general on a call log. And all he had to do for this was just a little lie where he writes a letter to Georgia and tells them that the department has concluded there's something amiss with the Georgia election. And as Trump puts it, just say that much and leave it to me and the Republican members of Congress. So obviously he wanted this as a talking point. He wanted to strike fear into the hearts of the Georgia election folks, and he was ready to sack the entire Department of Justice and install Jeff Clark in his stead. So where does Scott Perry come in? Scott Perry is a member of Congress from Pennsylvania who actually initiates this brilliant idea. He walks Clark into the Oval Office, makes the bridge, introduces him to Trump as basically a malleable guy who will do what Trump wants. So he really sort of does the initial arrangement, and I think counts as a co-conspirator in this particular scheme of subverting the Department of Justice and bending it to Trump's unlawful ends. So that's who Perry is. Now, what about going back to August? What about his phone? So the FBI seizes his phone and they have it. They need, however, another level of authority to comb through all the records in the phone, which are likely to be replete with calls to Trump and Clark, etc. And Perry, we now find out just now, what's been going on with it, we don't know. Now we know. Perry has launched efforts to keep the department from accessing his records on the ground that they are privileged by the speech and debate clause. The speech and debate clause, you probably know, it says that members of Congress can't be arrested while they're involved in speech and debate. And it's been generally taken to mean there's immunity for saying things, defamatory things, for example, while you're in speech and debate. So that's what Perry's trying to argue. To the extent we go by normal precedent, always a dicey proposition in the days of this Supreme Court, his argument stinks. Speech and debate is literally for speech and debate, things on the floor where you're making your point or countering your opponents, engaging in legislative action. Here, Perry's phone obviously is for all manner of stuff. Maybe a little bit on the floor, probably not. Maybe, getting his dry cleaning, but that by law, the FBI would have to disregard. But then the actual scheming with Trump, with West to put them together, that ain't speech and debate. At least as it stood before. So anyway, he's made this claim, however, and we now learn also this week that the chief judge of the D.C. District Court, Beryl Howell, rejects it, holds that the DOJ can have access to the phone, and says he doesn't have a strong speech and debate claim to stop it. Now, however, he goes on appeal, and that happened. All this we've learned just in the last couple of days. We've been wondering what's going on with Scott Perry's cell phone. He takes it to the Court of Appeals. There's a 3-judge panel there, and they grant a stay. There's not an indication as of yet that they agree with Perry, but they do what courts of appeals will often do: enter a stay to freeze the linebackers and keep Perry from losing his rights while they decide on it. So they enter the stay, and Perry, although he says today that the Court of Appeals got it right, that's really hugely overinterpreted. All they've done is put a stay into place so they can consider the arguments. And the arguments, I think, are going to be next in a few weeks. They've already decided the panel. It's a couple Trump appointees. I think it's Henderson, Rao, and Katsas. And they'll decide whether Perry has a good speech and debate claim. If he doesn't, then they'll appeal it to the Supreme Court. If they don't take the case, then the FBI can finally have at all the information that is stored in Scott Perry's phone. In the meantime, with the switch in the House in the person of Kevin McCarthy has waded into the fray, has filed a motion in support of Scott Perry, their fellow traveler, saying that they want to protect the prerogative of members of Congress and expansive interpretation and speech and debate, etc. So we do have a little bit of new alignment of the players, a favorable for Perry panel in the D.C. Circuit, but a claim that's so weak that the only way you can imagine his prevailing would be a real change in current precedent and an alteration of what it means to be undertaking speech and debate. So there you have it. Next thing to come is the actual argument in the Court of Appeals on appeal from Chief Judge Beryl Howell's ruling that he doesn't have speech and debate protection, and the 3-judge panel of the Court of Appeals will take it up. I think that'll be worth a talk to you when the time comes. Hope you agree. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.